So, given a number of recent legal developments in multiple jurisdictions, the investigative circle is tightening around Donald Trump. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So there have been a lot of recent legal developments, and they all seem to be converging to push the justice rock up the hill. Let's start with the Supreme Court, because just yesterday, the Supreme Court told Donald Trump, no, you can't hide evidence from Congress by claiming executive privilege. Here's the headline. In rebuke to Trump, Supreme Court allows release of January 6 files. The House committee investigating the riot received hundreds of pages of documents from the former president's White House within hours of the Supreme Court's ruling. That's a good development from the Supreme Court. Okay, how about Congress? What about the January 6 probe? Well, the House Select Committee investigating the Capitol attack is subpoenaing Rudy Giuliani, Sidney Powell, Jenna Ellis, and others, and the panel is seeking information, let's call it what it is, evidence from Ivanka Trump. Now, this request for evidence and testimony from Ivanka is likely a precursor to a subpoena if, and this is a really important if Ivanka refuses to provide the relevant evidence, likely the incriminating evidence she undoubtedly possesses about her father's conduct. So really, the only remaining question for Ivanka Trump is, how does she want to be remembered? How does she want to be viewed moving forward? Does she want to be viewed as a patriot, or does she want to be part of the cover-up of her father's crimes? Now let's turn to the most recent development, Georgia District Attorney Fani Willis going after Trump. Here is today's reporting from the Atlanta Journal-Constitution. Headline, Fulton District Attorney requests special grand jury for Trump probe. And that article begins, Fulton County District Attorney Fani Willis is requesting a special grand jury to aid in her investigation of former President Donald Trump and his efforts to overturn Georgia's 2020 election results. In a Thursday letter to Christopher S. Brasher, Chief Judge of Fulton County's Superior Court, Willis said the move was needed because a, quote, significant number of witnesses and prospective witnesses have refused to cooperate with the investigation, absent a subpoena requiring their testimony. Okay, so with the Georgia special grand jury investigating Donald Trump's crimes, there will be more subpoenas coming from that grand jury. And I think it's fair to say, okay, Glenn, come on, more subpoenas? What good is that going to do? Look at what witnesses do with congressional subpoenas from the House Select Committee. They disregard them, they defy them, they deride them, they mock them, they ignore them. You know, Mark Meadows was subpoenaed, and that news was met with, much rejoicing. Mark Meadows blew it off and was voted in contempt of Congress and referred to for prosecution 38 days ago. And he's still in the wind, prancing around footloose and fancy-free, and the House Select Committee has obtained not one word of testimony from Mark Meadows. And of course, others have been ignoring and defying congressional subpoenas. How about subpoenas in civil matters? For example, New York State Attorney Tish James has subpoenaed Donald Trump and Don Jr. and Ivanka, and they're fighting over those subpoenas. And who knows how long that court battle is going to go on. And so now, okay, a Georgia special grand jury, more subpoenas, what good will that do? Well, stick with me for a minute, folks. Let me do a quick breakdown of why all subpoenas are not created equal. Because subpoenas in the context of a criminal grand jury investigation, like is about to kick off in Georgia, and as we have in the federal practice, I'm going to talk about federal grand jury subpoenas in a minute. In the context of a criminal investigation, grand jury subpoenas are a whole different ballgame than congressional subpoenas or subpoenas in civil investigations. They can't be defied. They can't be disregarded. They can't be ignored. Because you know what happens after you've been served a subpoena to appear before a grand jury in a criminal investigation? If you don't appear, then prosecutors apply for a bench warrant. We send law enforcement out. If it's a federal case, we send the U.S. Marshals out. They arrest the person who has defied the subpoena, and that person gets hauled before the grand jury to testify promptly. And guess what? If that person wants to assert a privilege, whether bogus or legitimate, fine. Let that person offer a privilege to try to keep from testifying. You know what we do? We promptly go in front of the chief judge who has oversight responsibility over the grand jury, and we litigate the privilege. Not next week, next month, or next year. We do it right now. The judge rules, and if there is no legitimate privilege to be asserted, the judge orders that person back into the grand jury to testify. Done. So subpoenas in the context of a criminal grand jury investigation, like is about to kick off in Georgia, are a whole different ball of wax than congressional subpoenas or civil subpoenas, because the fights can go on endlessly over those other kinds of subpoenas. Not so with subpoenas in criminal investigations to appear before a grand jury. And that is why I get so frustrated that the Department of Justice has apparently some reluctance, some reticence to enter the criminal investigation fray. We don't know that for a fact, but we haven't seen a whole bunch of federal criminal grand jury subpoenas served on a bunch of folk who we know have information about Donald Trump's attempt to overthrow our democracy. And it leaves us all frustrated. Why? Because if DOJ was issuing subpoenas to appear before the grand jury in a criminal investigation, those witnesses couldn't defy those subpoenas the way they are with congressional subpoenas or civil subpoenas. They would be presented to the grand jury, or they would be locked up until they were presented to the grand jury. And it would all happen promptly and efficiently. No running out the clock. No weaponizing the delay in the criminal justice system the way people do when they're, served with congressional or civil subpoenas. And that is why the frustration mounts and the anxiety level is so high nationwide. I feel it because these things could be done promptly and efficiently. The law could be enforced in real time. Subpoenas could be enforced in real time. Progress could be made in holding Trump and company accountable criminally in a way that progress is not being made. Let's hope that changes soon. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.